Ignazio Castellucci. I teach Asian laws and Chinese law in the University of Trento, comparative law in the University of Macau, China. It's a pleasure for me to be here. I come every year regularly, invited by Ugo Mattei and Giuseppe Mastruzzo, to whom I'm grateful. And we normally have lots of fun when I come here to give seminars, because there is normally a very smart bunch of students with whom it's easy to have interaction, so please interact. Feel free to. And again, it will be a short and light seminar, as you already had a very long and intense lecture day. And the governance role of law in China, the case of insurance law. Why the governance role of law? What does it mean? Does the law have a governance role? What is this? Can you imagine? What is the meaning of this? We are trained to think in terms of the rule of law. That's what we know about the law. So we have a specified number of rules which are clear, which are public, which tell us exactly what we can do, what we cannot do, which are our rights, obligations. And then there is also a machinery provided by the state normally to apply the law in a technical way, so that the rules which are clear are exactly applied and the result is predictable and is equally applicable to all, whether a private person or a big corporation or the state itself that can be sued by anyone to have legal rights enforced. That's the theory of the rule of law. I don't want to make it complex because there are several theories on the rule of law, but basically this is what we think about the law. So the law doesn't have a governance rule. The law is the law. We have everything very clearly stipulated there. So what is the meaning of the governance rule? Governance is normally associated more with the management of a corporation, for instance, corporate governance. The implication of this word, the meanings can be several, of course. We have to keep it simplified now. But the meaning of governance implies that someone has some range of discretionality in management of something to obtain a result. That's roughly the idea of governance. It's obviously, even the word, it's clearly related to government, not to legislation. Legislation is the universe where everything is clear beforehand, because it's written, maktub. It's in the law. Government is you apply some degree of discretionality for some reason, to some purpose. So, how can you have a governance rule of law?
Well, first of all, by defining any concept of law, let's say by saying what is property, you already govern, let's say, to some direction, just by saying that this thing will be a property and this can be propertized.
Sure.
And also by saying what is property, you are saying what rights of exclusion.
Very good.
It grants. I mean.
Yeah, very accurate. Of course, that's part of the rule of law discourse, because you have the written laws or case law in a common law jurisdiction. Then you also have doctrines developed out of the statutory norms or of the case law, developing the meaning of many legal concepts. So property includes an array of rights and obligations to some extent. So if you read a legal document stating that you have a property right on this computer machine, you know exactly what you can do with that and what you cannot do, of course. So your accurate description is part of the theory of rule of law. Of course, if you have a different concept of role, of law, then also the role of the law can be different. Exactly. Yes, please.
So it could be one of the, let's say, forms of rule by decree.
Sorry?
Rule by decree.
Very accurate. Yes, I was coming to that. Comparative lawyers very often use the term rule by law. Exactly to make it, to contrast this term with rule of law. Rule of law, rule by law. And this is very often used in relation with comparative legal studies around Asia and China in particular. Precisely because, as your colleague suggests, there is the clear understanding that the nature of the law is different in a non-Western environment. So the nature is different, so the law is something different, so the role, not the rule, the societal role of the law is also different. And precisely, yes, what you are suggesting, rule of law implies that, for instance, rule by law implies, for instance, that in socialist China or in the Soviet Union, the former Soviet Union, the state or the political authorities use the law as a tool to govern the society. So that's a case of governance, because the state or the political authorities in such a context use the law to govern a multitude of persons, entities, and situations, but without being themselves bound by the rules of the law. So the state governs through the law, like a tool, but is not governed by the law. The state is not bound to some extent. That's the idea of rule by law. May I ask you, where are you from? You all?
Bolivia. Egypt.
Egypt. Fantastic.
Lithuania.
Lithuania. Tanzania. Pakistan. So we don't have a Chinese student now, but if you have a Chinese colleague, do ask him about rule by law, which is translated rule of law, but can also be translated as rule by law. There is an ambiguity there in Chinese, in the Chinese language, and it's an ambiguity which is reflected in the ideology of the legal system. So the socialist basis of the legal system is the idea that the law is a tool. And you come from a former socialist country. I understand you might be too young, maybe, but I'm sure you know enough. You know more than I do. But the ideology of socialist law and socialist legality and how a socialist legal system works. It's basic philosophy. So you may have a lot of legal rules. In many cases, they can be similar to Western rules. But in principle, the role of the law is different. In China, in the People's Republic of China in the 1950s or in the 1970s, the role of the law was the one of a tool to disseminate a political directive in the community. I can give an order or a political input to my party structure through the party channels, and that's a political directive. I can also give my instruction to the public through a piece of legislation. Still, the role of that piece of legislation will be a governance role. So the public must know that this is my directive. But then, when the moment of interpretation or application comes, or enforcement comes, the solutions might be different. Because there is a policy dimension in a socialist legal system which is prevailing over the legal dimension. So what really counts at the end of the day is the political interest of whoever is in charge that can use the law or may not use the law as well to reach its political objectives. This is true in the former Soviet Union. This is very often true in African countries. This is quite common in China. This is becoming common probably in some Latin American countries, like Cuba, for instance. And probably it could become common in Venezuela and other countries. I don't need to mention Bolivia because we have someone here which is much more knowledgeable about me on Bolivia. But the idea of the rule by law is basically a non-Western model of governance, which can be found almost worldwide. If you go east, if you go south, you quite often find rule by law models of governance, with the government which is not bound by the rules of the law. And the governance rule of the law is also becoming an issue in Western countries. More and more, comparative lawyers, sociologists, legal sociologists are investigating this dimension of the law. There is a quite famous Italian legal sociologist, Maria Rosaria Ferrarese. She wrote a book which is quite brilliant. I'm afraid it's in Italian only so far. Published last year, and the title is La governance tra politica e diritto, governance between policy or politics and law. And she studies and finds out how a governance dimension can also be found in Western law, within the rule of law, as a new dimension of the rule of law. And she makes the example of cases where public powers make recourse to contractual instruments to govern society, making agreements with private subjects to develop some public functions. Typically, when a government, a local government or a national government, makes some kind of contractual agreement with a private corporation to develop a piece of land, to develop a neighborhood, to develop an entire part of the city within the city planning scheme. That becomes a policy and a governance role which is carried out within the rule of law system, but within that general frame, then the implementation is given by a contract, by a negotiation with the private parties and so on. And another instance that Ferrarese studies in this very brilliant book, that's small, can be read very easily, very nice, bias. Another instance she makes is the one of adjudication mechanisms, where the courts also produce new results within the interstices of the legal system. Not just applying the rule of the law, so still within the rule of law, but also applying policy lines at micro level for spot cases, but still deciding cases in a new way, which produces new rules, new solutions for specific cases, which may or may not be reproduced in other cases. So Ferrarese is finding, and legal sociologists are finding, that there is a governance dimension even within the rule of law. Of course, in a socialist legal system, this is much more obvious. Everybody can see in China that a state court or a municipal court or a court of any level can decide a case according to the specific interest of that particular community on that specific time and location. And a similar case might be decided in an entirely different way the next day or the next week in the next city, because the conditions require a different solution. The idea in those contexts is that applying the law is like governing, and is first of all producing a result which is acceptable in community terms, in the best interest of the public, the political community or the local administration, first and more than just caring for the interest of the private parties of that particular case. So in those contexts, the law is one of the many elements which is taken in account. In China, for many years, there has been not much law indeed. The state was governed by the party through political directives and very few pieces of legislation. And those pieces of legislation were also very vague, very general. If you read a typical socialist piece of legislation, even a Soviet one, let's say of the 1950s, you don't really find much substance in Western terms. You don't find a precise allocation of rights and obligations in a socialist law. You only find very general principles and very precise indication of who is in charge. So a socialist law is very normally a delegation of power to administrative authorities, who in turn issue their own regulations or internal procedures to govern that part of public interest. So the law, in the West, the law stipulates rights and obligation, and the citizen reads the law to be informed about his rights or her rights. In a socialist, in a pure socialist country, the citizen doesn't have to read the law. Because the law is, first and foremost, a set of instructions for the public government officers. So they have to know which is the limits of their authority. And that's in the law. And then they can issue their own bylaws, regulations, or internal memos or procedures to exercise that authority. So the Western law gives rights. The socialist law distributes authority to the different levels of the administration. And that's a different model, social model of governance. Yes?
So when we will talk about this, of course we are like talking about this China, this economic boom there, that they have this company and companies, the investments things, they are all going on there. So, but I think that now they have this those acts like giving rights and duties to.
They have a lot of that.
Yeah, now.
They do, yes. More and more.
More and more.
More and more. I'm coming to that.
How do they deal when there is a breach of this distribution of power?
In fact, the most careful tension when drafting a socialist law is put by the lawmakers in distributing powers, not really in drafting the rights. And the breaches can be solved normally in a political sense, through party mechanisms in China, not through the administrative courts, or very often through administrative channels. If there is a conflict of attribution of power between two departments of the same government, the issue will be brought to the attention of the higher level.
Why would
The immediately higher administrative level, who is in charge of many things and also of supervising the two lower level officers or who have a conflict. So the solution will be there. It will be an administrative solution most.
Why does a government agency, where does their interest come from to challenge this
The interest comes from many reasons. I can just give you a very simple answer. If I have power, I like to have power. If I'm doing things, I like to do them the way I like. Because I am very committed, because I love my country and I want to do my job properly. But we may have different opinions on how to do this, how to do that. But I may also have a different reason. Power means a lot of things. Power brings benefits of legal and also not legal kinds. So if I have the attribution of deciding on construction permits, I might have a lot of benefit from that. I mean political benefit, of course. Because the people would say, this officer is a very good one. He's wise, he's very careful. In some cases I may have other benefits. But there are many reasons worldwide why different public offices might have a conflict of attribution powers.
And I can imagine the situation where one of these authorities looks at so much paperwork and they say, I don't want to do this.
There are also cases where you have a negative conflict. I don't want to do it, I'm busy, my wife is waiting me for lunch, I have to run, okay, this is not for me. So it depends. You may have positive or negative conflicts. Both want to do this or neither want to do that. It may be for many different reasons. I'm sure we don't need to get into it.
So even still when you're saying that they have a lot of legislation right now, but still the intention of any socialist economy is the distribution of power. So even at this time,
That's the basic model.
That's the basic.
The basic model and the theoretical model. You obviously don't have, when you discuss a theoretical model, you normally make an abstraction.
Okay.
So I'm discussing the extreme socialist model and the extreme rule of law model, just to make a few concepts clear. Of course, you don't have in real life an entirely rule of law legal system, which is 100% rule of law. You don't have it. Not even the most rule of law state, like the United States, is a 100% rule of law state. Not even North Korea is a 100% political state. But you have to identify the models so you are able to see the dynamics or the different tensions that affect the final result. So probably you can imagine a graph with a simple line, rule of law and rule by law, and maybe identify your national legal system at a given point in this scale. So Pakistan might be more ruled by law than England, but can be a lot more ruled by law, rule of law than North Korea or China. So it's just, we are discussing models, so obviously it's an abstraction. It's just to identify issues. And so I basically discussed two different governance models here. Governance, in a large sense, can mean how you govern a society or a complex system. So you can have a governance model based on the rule of law, which is the Western one, and another one based on the rule of man, which is the governance of a village in rural Tanzania, where you have the head of the village deciding cases every morning according to the need of that particular moment and according to the knowledge he has of every individual member of the community. That's what current lawyers call rule of man. So no abstract rules, no pursuits, just authority and understanding of each individual member of the community. That's another extreme. Every society, every complex society has a mix of these three different polarities, we may say. So if we observe rule of law and rule by law, we can say that the Western rule of law has a number of features which are quite peculiar. Division of powers. And judicial review, we may say. Or checks and balances. Because the Western theory is we have clear rules of law. We have a government who is different from the lawmaker who must follow the law. And we have an independent judiciary who checks. So this way, we only have the law applied at all times. That's the theory. And to have this model working, we need separate powers and the possibility that one power checks on the other and the other checks and balances. That's the lesson. A socialist legal system is based on an entirely different assumption. The assumption is there is no division of power. Because the power is only one, is with the people, represented by the party, and then the state is just a piece of machinery to implement the political will of the people and party. So the legislation and the government and the judiciary, it's all part of the same state. It's just different functions, but not powers. So they are just instrumental, like tools in the hands of the party to govern this enormous society like the case of China. So there is no checks and balances, no division of powers. The critical keyword, I would say, in a socialist legal system is not division of power, is not checks and balances. The critical word is probably supervision. That's the mechanism that substitutes powers and checks and balances. Supervision. You have a state machinery with many functions, but basically with a hierarchy. And each level of government, including the courts, is supervised by the higher level. And the top level of the state is controlled by the political will of the party, which is the political will of the people. That's the different model. That's the socialist view of state. It's a different model of governance. In that model of governance, you don't need very detailed pieces of legislation, really.
Can I interrupt with the questions, or should I wait till then?
No, you do, please.
So my question would be, what today ideology is being used to justify this, or no one questions that? Because usually to justify somehow this type of system as a tool, as ideology, because we know the best, state will do it for you. So does someone even bother to justify it, or this question doesn't arise? They do? So what's the justification?
I am coming to that. The justification is that China is a socialist country. So in their constitution, in the constitution of the Communist Party, you have that China is a socialist country based on the doctrines of Marxism, Leninism, and on the thought of Mao Zedong, and then on the doctrine of Deng Xiaoping and others. So the political basis of the state is still socialist. This means that the party still caters for the well-being of everyone. And that China is still a country where the community interest prevails over individual interest. So now that a market economy exists in China, they still define it as socialist market economy. So this means that you have an economy, you have a market, you have very modern market pieces of legislation, including contracts, trust law, company law, you name it. They are all in, and they are all state-of-the-art pieces of legislation, created very recently by comparing the best models and pieces of legislation available worldwide. So their laws tend to be good, improving, better and better. But still, those laws are for the markets. And still, general interest prevails over private interest. If there is a contrast, a conflict between a private interest and a general one, either the courts will interpret the law in a different way, or they will not enforce it. Because you have those very modern rules, but you also have everywhere in the legal system a lot of rules protecting the general interest, stating clearly that no legal act, no legal transaction, no interpretation of any piece of legislation or regulations can go against public interest. And the socialist idea of public interest is much wider than the Western concept of ordre public, public order or public policy.
And regarding hierarchy, is there like...
So they have a lot of latitude to apply the law in different ways, including disregarding it if the need comes for the benefit of the general interest. That's why you cannot win a case in court in China if you are a foreign entrepreneur and you think you have to win the case against a local enterprise, which is public owned. Because if you win that case, that enterprise will lose its resources, maybe will have to close, will have to send people on the street. That would be a social problem, an economic problem for the local community, and the local court very easily will not enforce the articles of this or that law in your favor, because there is a general interest here that must prevail. So in China, you only make money if they also make money. That's the idea. There is a communitarian concept of contract.
What about the spread of the law? I mean,
What?
the spread of the law, going to fairness and...
You still have to consider the law because, as your colleagues say, the law is more and more present. Chinese society is more and more legalized. It's changing very fast. So there is a tension, as she was suggesting, between new ideas about the law and an increasing presence of the law and its technicalities, and the basic original assumption that China is a socialist country. So that's why it's really unpredictable what the outcome will be in 15 years from now. In the early 90s, some scholars observed that China was finally running towards the rule of law. And they were so happy everywhere in the West because they would be a rule of law state, because they said so, because they are doing the legislation. And actually they got it wrong. Because China is doing the legislation, it's enacting more and more laws, because the leadership understands that the socialist economy, that the economy of China, needs clear rules to work. So there will be confidence, there will be investment, there will be business, but still, they reserve the right to intervene, to interfere in the market if the public interest so requires. This is the difference. And this makes the Chinese rule of law something very different from the Western rule of law. So to some extent, the Chinese rule of law is still some kind of rule by law. Because they have the rules, because they are useful, but those rules can also be bent when necessary, or disregarded, or avoided because the parties will find some other negotiation to avoid the confrontation before a legal court. So there is a number of tools that a good lawyer must be able to use in China. You not only have to understand the law, You have to study the law. You have to know it well. You must be a lawyer like you are. But also, you have to understand the political dimension of what you do, the administrative interests involved in any kind of problem you have to deal with. And you probably must be able to consider all these different influences in your work. Yes.
In Western countries like courts, they regularly, I mean, of course in civil law countries there is always like this theoretically that courts cannot interpret the law.
That's the theory.
I mean, like interpret the law against which is written there, like especially in civil law countries a little bit strict, but in common law courts regularly do. But how about in China?
Well, in the West, you know everything. I don't have to spend much time on that. So, both civil law and common law countries have reached a level of evolution that makes clear to all of us that Italian courts made law, Egyptian courts made law, Lithuanian courts made law, sure. But still, the socialist theory is that the courts just apply the law and should refrain from interpreting too much. That's also the case in Lithuania, I think. There has been a research, maybe in 2006, at the World Congress of the International Academy of Comparative Law, on the value of the precedents in the legal systems of worldwide. And there is a book written by Hondius, Professor Hondius, who was the general reporter, and he collected national reports from many different countries, including a national report from Macau, which I wrote. But I'm not talking because I wrote it. It's just because Hondius concluded that everywhere it's clear that the courts make law, but still, in socialist country, there is a strong resistance to this idea. So courts, even former socialist countries, still have this tradition that the courts do not dare too much. And they still do it, and they do it in China. So the point is the courts simply produce a given result if the case is sensitive, critical, or has a political dimension, after consulting with the appropriate procuratorate or judicial committee within the court, or with the appropriate organs of liaison between the court and the party, the local party, so that the solution is always politically accepted. Courts don't dare much in China, independently, out of their mind, they don't. So the system is very tightly controlled. And the party, through the state machinery, has the possibility to work with it. That's why normally socialist rules are not so detailed and precise as the ones we normally use in the West or in Pakistan. Even in China, if you check market laws like company, contract, trust, they look very Western. They look very Western. Almost the same. If you check modern Chinese laws in the areas of public law or administrative law, they look very socialist. They still look very socialist. Because the idea is that market is a tool to create resources, wealth, but still is part of the socialist system. And the wealth then will be distributed. And whenever there is public interest involved, you will see that the rules are drafted in a very different style. If you check the environmental protection law and the contract law of China, they seem like two completely different things, written in entirely different countries in different centuries. Because China has this contradiction, which is not a contradiction, but may look a contradiction to us, of being a socialist country with the biggest market in the world. And in fact, you see that the law in China has different modes. has variable geometries, like the wings of military jet fighters, that can adjust their shape according to the different speed or combat situations. So the law in China can be very sophisticated and technical for contracts, for market situations, and is still very socialist whenever there is a public interest involved. So the very interesting issue is to see where is the limit between the different areas of the law and how the law behaves in the gray areas which are between public and private law. Property law is one of the cases. In a socialist country, property is critical. Politically, property belongs to all. But still, Chinese people can buy a house now. So you see that Chinese property law is very detailed in all the respects of enjoyment of property or relations between neighbors or relations of the owner of an apartment with the management of the building. You have a lot of rules. But you don't find in that law how you buy a house. So there is a lot to look at in the different ways and the different modes of the law in China, which follow the different implications of what needs to be regulated. If it's purely private interest, you more and more will find detailed rules. If there is any kind of general interest, you will see that the rules are drafted in a different way. And you always have those general rules like protection of public interest and so on. You still have rules saying that when the law doesn't provide a solution, the party policies will be used by the judges to decide cases. You still have it, it's still in force. So you see that it's a complex world with a complex legal system that has different dimensions. It's not a monolith. And even the boundary between private and public law is different than the one we think. What is private law for us is public law in China. How do I buy a house? I get a civil code of Italy and I can find it. In China, buying property has a political dimension. How do I develop a neighborhood in Italy? I can buy a code with all the administrative laws on zoning, on city, zoning or planning, and on development of land. And I understand how I can make a project and develop the land. And then I can buy the civil code for 10 euro, and I can read all the articles about how I sell the houses. In China, all this part is political. It's part of the public law. Some parts of this is public law, even in Italy, but the boundary is different. Insurance. Why insurance law? Why we are discussing insurance law tonight? Because insurance law is private. You buy insurance for your motorbike or car. It's a contract. It's a business contract. It's a vital function for market economies. Like banking. You cannot have a developed market economy without insurance and banking services. But still, insurance and banking institutions have an enormous macro dimension because they move a lot of money. And the amount of money which is managed by banks and insurance companies can affect the general features of the market. So this is part of life in the West. The banks are private institutions, the insurance are private institutions. They collect a lot of money, they use it to make more money normally. They invest their money the way they like. They are private. Banks and insurances are private entrepreneurs in Italy, in Lithuania. They might belong to the state, but still they are enterprises working on the market. What they do with the money is regulated by private to a large extent. Even if this can affect the public, if the Italian insurance companies or banks decide that the money, their money is better invested in a given kind of stocks or investments abroad, they will do it. They will make a lot of money, even if this will be detrimental to the Italians, because a lot of money goes abroad. There's nothing we can do as Italians. They are private enterprises, they manage the money they want, the way they like. In a socialist country, this is not accepted. The amount of money which is collected through insurance contracts must be managed according to the directives of the state. Because this movement of large amounts of resources can affect the economic system in general. So it's not possible that it's managed by private individuals without the state having the possibility to check. That's why insurance is a good example to study how in a socialist country the law can play a governance role and how the limits between private law and public law can be different.
We have some aspect, of the Western, in Jordan already, of the Western countries, system of insurance company, and the Chinese one, for example, if insurance company undertaking risky business, they must have insurance on their company.
It's called reinsurance.
Yeah, exactly. So, that's some aspect of the intervention of the government.
Very good. I tell you more. In every country, even in Italy,
but it's not mandatory for let's say a non-risky insurance company. So they don't require all the company to do that.
Yes, but it's again a matter of identifying two models, two extreme models which are abstract. You don't find them anywhere. And then you observe real cases like China, Italy, Jordan, Egypt, and you identify which of the two models is more influential, or which is the combination, is 70-30 or 50-50 or 90-10. On one side, you have the liberal model. I sell insurance services, you give me your money, I insure your interest, and then I use the money for my use, to do what I like, to make more money. If I'm good, I will be richer, and you will be happy because I will be able to pay when you have a damage. But in every state there is a public control, of course, because there is a general issue, a general interest that insurance works well and safely. So of course there are public agencies checking what the insurance companies do, checking their proper behavior, checking that they do not take excessive risks. But still is a matter of how much you can check, how far can you go with your interference. In China, until 2 years ago, the insurance companies, according to the law, could only use the money to buy certificates of debt issued by the Chinese government, or the bank deposits with Chinese banks, which are also owned by the state. This means, and now I tell you something. Please don't forget what we just mentioned. In Italy, you know that we are one of the most indebted countries in the world. We have an enormous public debt. I think it's the third in the world, after the US and probably Japan. Are you Italian? Where from?
Palestine.
Pakistan. Okay. You know about Italy.
Palestine.
Palestine.
Oh, Palestine. But I'm sure you know about the Italian public debt. So I give you some data. Last year, in 2010, the approximate amount of the certificates of debt of the Italian government sold to the public was of 220 billion euro. It's a big, it takes a few seconds to understand how much is 220 billion euros, but it is a lot of money, of course. So this is 2010. In the same year, the total amount of premiums, or should we say premium, because it's Latin, I don't know. The total amount of premiums or premium paid in Italy for insurance services is between 50 and 60 billion euros. This means that the amount of resources collected last year by insurance companies is about 1/4 of the total amount of the debt produced by the Italian government. This means that in Italy, companies can use the money the way they like to make more money, to pay dividend to the shareholders, to pay a lot of bonus to their managers. Okay? So there's nothing we can do. Insurance companies make money, and the Italian government makes debts. Imagine if all those monies collected by the insurance companies could only go in the pockets of the government. You save about 25% of debt. You have to make that particular year. In macroeconomic terms, in political terms, this is an enormous difference. In one case, companies become rich. In the other case, companies make money because the government certificates also have a price. They pay an interest. But the government can finance its activities at a much lower price because they need to buy less capitals on the market because the insurance companies have to give the money to the government. So I need to buy less capitals, I need to pay less interests. My certificates of debt would probably be in a higher demand because there are not so many and so on. So there is an important economic impact. In general terms, this means that the Chinese insurance companies work in a private law environment when they sell you an insurance policy. You have a motorbike, you buy your contract, that's private law. So the front office of a Chinese insurance company works in a private law environment, but the back office is not working in a private law environment. They cannot use their resources to make investments worldwide. They can only deal with the government. So, in a sense, the back office works in an administrative law environment. In the mid-80s, in China, there only existed state insurance enterprises. So the state was giving insurance services to those who needed the insurance. In this mixed model, you have private companies, but they still have to deal with the state. It's like a concession economic model. They can sell contracts to the public, but they have to deal with the government almost as if they were part of the state administration. Sort of an external arm of the government, enabling the government to make policy through the administration of insurance contracts and the resources collected so far. That way, especially in China, the government tells the companies how much they can ask for insurance services. So they don't have the freedom to choose a price. They have some range, but the government makes the price, the government manages the resources collected. So the companies are something in the middle to make the system more efficient, maybe, for the public, for the benefit of the public. But the macroeconomic dimension of the insurance industry is well regulated by the state, in a sense. Much more than it's regulated in the West. In England, in London, more than 15% of the total volume of exchanges in the London Stock Exchange is made by British insurance companies. Only British, not the foreigners, just the British. They make more than 15% of the total volume of the London Stock Exchange. This means that the English companies of insurance manage the resources they have on the markets. So they sell contracts in the market and they use the resources they collect on the market. It's an entirely different governance model from the government point of view. The English government cannot interfere and don't have access to the money of the insurance companies unless the government issues a certificate of debt with very good interest and the insurance companies go and buy them. In China, the government is entitled to have those monies available by law. The reform in 2009 says now that insurance companies can use the resources in real estate investments, in public certificates of deposit of the state, and also to buy stocks in regulated stock exchanges. But the law is very general, just says what I just said. Don't say more, don't give any detail. And then says that there is a government commission supervising the activity of all insurance companies that will give instructions, guidelines, or regulations on how to use those resources. So this is a case of using the law as a governance tool. It's a clear rule by law. In the 90s, you have to give me your money. I am the government, you are insurance companies. I will keep your money. Now probably China has a lot of liquidity. The government of China has a lot of financial resources. It's buying the foreign debt of many countries. So probably they don't need so much money anymore, I'm not sure why. But since 2009, the government says to the insurance companies, you can use the money in A, B, or C. And I will give you the details every year. I will tell you what you can do. So there is a clear identification of one administrative authority who has the power to issue detailed regulation whenever they think it's appropriate to tell the companies how they must allocate the resources they gather. And this gives a lot of latitude to the Chinese government to make politics, to make policy with those monies. So this year I want to foster the real estate market. I want to give incentives to the development of housing in the western provinces of China. I will give you a directive. I will give a directive to the insurance companies that they are encouraged to invest the resources there. So the government of China can make a lot of politics and policy using resources which formally are not in the government's pockets, but through the law can, again, encourage the companies, insurance companies, to put their monies where they say, where the government say. So that's a very clear case of how you can use the law for government's purposes. To create, not to give a clear indication, but to create a space for further negotiation or adjustment or administrative pressure or indication or order on how to manage. And this makes a lot of politics possible. You know everywhere, you know that everywhere to make politics you need financial resources. The Italian government has a very poor education policy, and then everybody complains because there is no financial resources enough to have the education system improved. It's always a matter of money when you want to make politics or policies. If you have the resources, you can do many things. If you don't have resources, you have a problem. So in this case, there is a number of millions of euro or billions of euro that are available every year in the insurance company's pockets. In a liberal market, they can use those monies the way they like. In China, they will use the money the way the government wants. Is it clear?
But I mean, you still direct the revenue of the Italian insurance company through taxes. I mean, the government has a big share.
You can also do that.
I mean, no, I mean, they direct the revenue directly. You do it indirectly here.
Sure, but this is one more instrument.
Also,
You can also ask everyone to pay taxes.
yeah, also
This is one option more.
there's a relation between risk and return. I mean, the Italian insurance company go through risky businesses, so that means more money, more revenue, more taxes for the government.
Sometimes if you go through risky business, you lose everything.
Yeah, but if it works, there's more return than the Chinese company. I mean, than the Chinese insurance company.
It's debatable. If you risk too much, very clearly you may make huge profits. And definitely the management will make huge bonuses at the end of the year. But if you have a large insurance company engaging in risky business continuously, if the company goes bankrupt after some years, there will be an enormous general damage to the general public. And probably a socialist government doesn't want this to happen, doesn't want the possibility to exist. So it's, of course, again, if you take abstract models, the more a system is liberal, the more risk is encouraged because it's part of entrepreneurship. Risk can be insured. Risk is good because risk means the economy making problems. In a more conservative society, risk is not good. In some parts of the world, risk is forbidden by the law, which is a religious law but can be also a positive law in some states. The Sharia forbids the Gharar transaction and also the riba transaction. So there is, according to different cultures, a different perception about risk. In a liberal world, in a Western liberal world, it's considered good. In a classical Islamic environment, it's considered the devil, something that must be avoided because makes someone very rich to the detriment of the many who get poorer. So at the end of the day, it's a matter of a political decision or what you want from your community. There are situations in the middle. Civil law countries admit risk, admit that risk is positive, but in a less extreme way than the common law tradition. And the Chinese society is also risk averting to some extent. The Chinese love to gamble. They go to Macau and they gamble very much. But in their common life, they consider the risk something that can be insured, but first of all must be avoided. So they have a different attitude. Attitude towards risk is also another way to define the general ideology of the society. So it's not necessarily good, it's not necessarily bad, it depends. That's why you compare different legal systems and traditions, just to observe and to identify the pros and cons of everything and how things can be different. And not necessarily one is good and one is bad. In China, they have this system. Probably companies make less money than Western companies. And on the other side, probably Chinese companies do not go bankrupt. Because there is a number of safety nets in the law and in the politics to avoid that.
They get bailed out in case they are in risk of default.
They will never be in risk.
The
The state will intervene. There are specific rules which are different from common bankruptcy rules to make sure that if something happens and an insurance company in China is going through difficult times, the company will be managed by the governmental authorities to make sure that all existing contracts are kept safe and no new contracts are done, for instance. This doesn't happen in Italy, where we experience a number of bankruptcies involving insurance companies in the past few decades. So it depends. Basically, if the government has more resources available because of this system, the government has more resources to take policy actions which could not be taken in England, because the government has not got any special access to the resources in the insurance company's budget. So there are pros and cons, of course. You cannot just decide which is better just observing one particular side of a very complex reality. You can only assess the overall reality. Otherwise, how can you know, it depends. It's never so easy. There would be many things we could say, and I guess it's late, so I'm probably going to stop here and listen to your comments and questions. So yeah, one thing we learned with comparative law is that you never say this is better than that. You should never do it anyway. And you do it with persons also. This person is better than the other one. Why? Because she's nicer than the other one. But maybe the other one is more intelligent. Or that boy is better because he's rich. Yes, but he's also such a handful. Maybe the other one is a better person. So you just don't judge by small segments of anything. Okay? Any comments? Any questions? Okay, I think we're done.
Yeah, but just this one last thing I want to ask you that China is a socialist economy, after all. So are not those big companies owned by state?
Many of them, like many banks, by the state or by provincial governments or by more local authorities. It's now possible to have private-owned insurance companies. And even foreign companies may access the domestic market now with a lot of limitation and controls. But still, most of the big insurance companies in China, like the big banks, are publicly owned, either the central state or the provincial governments and so on. So that's the reality. The reality, that's why, one of the reasons why it's a socialist economy. Because the state is the biggest actor in the market, is the owner of the market, is the regulator of the market, and is also the main actor of the market. So we can also go there and do business. We can have business amongst us, and it would be perfectly regular business. But if we do business with the state, we have to understand that the state is not just like us. It's more equal than us. We are all equal, but the state is more equal than all of us when doing business. Because it's a socialist system.
Regarding health insurance, is there a distinction between private health insurance and public health insurance?
Not really. Well, you probably know that the state of public health services is quite poor in China, especially in the western provinces and in the rural areas. So that's an important problem. Probably in the future there will be more and more insurance services bought by the Chinese who have the money to afford it, precisely to care for health needs, because the public system is very basic. So China has a problem. It's really developing from a state which was almost non-existent to the biggest state in the world, to the biggest economy in the world. So they really have to build everything from scratch. They have to build a tax system, they have to build a health system and health insurance system through public channels, and then also you can discuss the private ones. So far you only have the Chinese wealthy persons buying private insurances and the other ones going to the hospital when they need attention, to the local doctor. It's still very in the making, so again, we need to observe China in 20 or 30 years to have a reasonable assessment of what is going on now. You know that Zhou Enlai, very famous leader in the 20th century of the Communist Party and of China, was once asked after a conference, which was his opinion about the French Revolution and the impact of French Revolution on the Western world. And the answer was, it's still too early to say. So they also have this vision of time. And in fact, everything is changing so fast. So you probably can make an accurate assessment in 20 years from now. Okay? Thank you very much.